It's a one-page opinion, but it does not contain a single one of the propositions of law that plaintiff relied on. Giving plaintiff counsel the benefit of the doubt, we searched for another case called In re Kapmeyer. We were able to locate it. There is a Supreme Court case with that name. The recorder and other identifying information is not what was cited in the motion or in the response. And this other In re Kapmeyer case only deals with it's a joinder issue and does not contain.
An attorney is standing before a judge, admitting he used AI to research his case. What he's about to confess will shock the courtroom. This is Travis County Court at Law in Texas. Plaintiff Gonzalo Pacheco is suing the Victoria Glen Homeowners Association and its former president, Robert Cruz, over HOA fee disputes. He's represented by attorney Ed Lee. The defense attorneys, Andrew Willard and Jake Dima, filed a motion for summary judgment, arguing Pacheco's claims are time-barred under the statute of limitations. Lee filed a response citing multiple court cases to counter their argument. But Willard and Dima discovered something disturbing about those citations. They sent Lee a letter demanding he verify his sources. He never responded. Instead, he showed up to court and doubled down. Now, Judge Todd Wong has to decide what happens when an attorney brings fake case law into his courtroom.
So what I've got on my docket here is a motion for reconsideration of a defendant's motion for summary judgment from a while back, and then motion for sanctions due to some case law citation and other things that I guess the defendant wants to talk about. So there was a motion to object to a visiting judge, but y'all already agreed to one before. So you've kind of waived that. Doesn't really matter because I'm hearing the case right now. So that's really not on my docket. All right. So let's go with the defendant's motion for reconsideration. Either Mr. Willard or Mr. Dima, you may proceed.
Yes, Your Honor. Andrew Willard for the defendants. As I stated earlier, I represent both defendants, the Victoria Glen HOA and his former president, Robert Cruz. The plaintiff, Mr. Pacheco, is a resident of the HOA. He has filed a lawsuit against my clients asserting breach of contract, declaratory judgment, and a breach of fiduciary duty. The breach of duty is only against Mr. Cruz. Essentially, Mr. Pacheco is arguing that he's being incorrectly assessed his HOA fees by the HOA, and this is resulting in him being overcharged compared to some of the other residents. The motion for sanctions is being filed today because we had previously filed a motion for summary judgment seeking to dismiss all of Mr. Pacheco's claims as a matter of law because they are time barred. On November 25th of last year, we argued this motion in front of Judge Burgess. At that hearing, counsel for the plaintiff relied on and cited to multiple cases that either don't exist at all or to holdings and propositions of law that aren't actually in the cases that were cited. I'll get into this in a little bit more detail, but it was very clear at the hearing that Judge Burgess took counsel's citations as if they were in fact true, and then ultimately denied our motion for summary judgment. We're here today asking for relief from the court. Specifically, if the court's so inclined, we'd ask that the order denying defendant's summary judgment be vacated. The plaintiff's pleadings filed in response to the motion for summary judgment be struck due to the false and inaccurate case law. We'd ask that either our summary judgment be granted on the merits in its entirety, or that the plaintiff's claims in this case be dismissed as an appropriate sanction. And finally, if the court's not going to permit us to argue our motion for reconsideration today, then we'd ask that we be permitted to reset the summary judgment for a rehearing at a later date. I'd planned on getting into a really descriptive explanation of what happened. However, plaintiff has filed a response to our motion for sanctions, I believe on Tuesday, or perhaps it was yesterday. In that response, just to summarize, counsel basically admitted his conduct, fell on his sword, and and has addressed the issues, agreeing that there were false and fictitious citations. So I don't want to belabor that point, but I would like to walk the court through what happened just to explain the nature of the prejudice to my clients. As I said earlier, we filed a motion for summary judgment based on the applicable statute of limitations, saying that these claims were time barred. Plaintiff then filed a response to our motion that I'm going to call the original response. And Your Honor, I don't know if you have a copy of our motion for sanctions pulled up, but I'll show you Exhibit A. Basically, in plaintiff's original response to our summary judgment, he cited to a single case for multiple propositions of law, about 6 different propositions of law supporting his arguments. And he even pulled a direct quote from that case. On my screen, that case is In re Christopher Kapmeyer. It's a 1-page opinion, but it does not contain a single one of the propositions of law that plaintiff relied on. Giving plaintiff counsel the benefit of the doubt, we searched for another case called In re Kapmeyer. We were able to locate it. There is a Supreme Court case with that name. The recorder and other identifying information is not what was cited in the motion or in the response. And this other In re Kapmeyer case only deals with it's a joinder issue and does not contain any of the legal authority. So a week prior to the summary judgment hearing, we sent counsel a letter, which is Exhibit C, which I'm showing you, just explaining that, we were unable to find it. We think that, the citations are incorrect. And we asked that he either send us a copy of the case, send us the correct citation, or resolve the issue. We never heard back. All we got was a second response to our summary judgment, completely removing all citations to Kapmeyer and then citing a host of new cases. And in the second response, again, there were multiple issues of fictitious citations, what we believe are AI hallucinogen cases. And there was at least 3 cases that we identified that either a direct quote was pulled from that does not exist. The recorder number took us to a case that is not the case that was cited. And then there was another quote that did not exist. However, in our opinion, the most concerning case was a case called MBM Financial Corp v. the Woodlands, which plaintiff cited to as a Texas Supreme Court case. Plaintiff at the hearing in front of Judge Burgess stated affirmatively to the judge that this case recognized an ongoing economic breach as giving rise to a recurring cause of action, essentially arguing that every time Mr. Pacheco was assessed, it either told or reset the statute of limitations. This case does not mention that. Counsel made the affirmative representation at the hearing that this case was Texas Supreme Court case law. It was controlling law. The reason that this case is so important, that due to its miscitation, and in fact, that case really only stands for the proposition that attorney's fees can be awarded in addition to nominal damages or something along those lines. And that doesn't even talk about this recurring violation rule, which again is not an actual Texas doctrine. But at that hearing, once this case was cited, I brought it up to Judge Burgess and said, Your Honor, I should have addressed this probably at the beginning of the hearing, but we believe this case, the citations from this case are false, or there's hallucinogens or any of the, the hallmarks of generative AI being used. I don't think the judge understood the allegation that I was making, because his next question to me was essentially, well, do you have a Supreme Court case that rebuts that proposition of law? And then shortly after that, he denied our motion after we had a discussion about whether the continuing violation doctrine existed or not. I've never had to file a motion like this before, and I don't enjoy doing it now. However, just the fact that the original response was filed with fake cases, we informed counsel that the cases were fake. A second response was filed with fake cases. We did not inform him because it was right before the hearing. But then the fact that it was doubled down on at the hearing in front of Judge Burgess, and clearly was a deciding factor in our summary judgment being denied. We wanted to bring this to the court's attention and show that our client has been prejudiced, because the issues before the court on the summary judgment are very clear. It's just statute of limitations. And there's very clear case law that if we're allowed, Mr. Demo will explain to you, Judge. And so essentially we're here. We cited a whole host of cases in our motion for sanctions addressing, what the hallmarks of AI generated case law look like, and then also what courts in the Northern District of Texas, Eastern District, the Eastern District, and then some other circuit courts have decided are appropriate sanctions. And so today we're asking